Good morning, my lady, my lords. I appear on behalf of the appellant Candey Ltd.
Yes.
Mr Sharifi behind me. My learned friend, Mr Cohen QC, appears on behalf of the respondent, Mr Miller. Can I first apologise, because I think we're in the wrong places.
I wondered.
Being out of practice for 2 years meant that we've set up incorrectly, and we'll sort it out at lunchtime, if that's all right.
That's quite all right.
Thank you, my lady.
Mr Hack, have you had a chance to speak to Mr Cohen about timetabling for the day?
Not particularly. I don't envision any problems at all, but is there anything specifically?
No, it's just the court has read all the material. We've read your skeleton arguments and feel very familiar with the territory, and you can go straight to the heart of the matter.
All right then, my lady. And I'll certainly do that, and we'll say we don't anticipate any issues at all, and I'll speed up according to the indications that you might give. My lady, my lords, then this is a case which is about an assignment by a solicitor of a former claim, a claim by a former client arising after a damages-based agreement. And as you'll see from the way that we've put it in the skeleton, this is something which doesn't arise frequently. As far as we can see, it's the first time it's happened.
Was it a damages-based agreement? Because there's a reference in the recitals to it having been a CFA.
Yes, that was an error.
That was an error. It was definitely a DBA. It was
definitely a DBA, under the terms of which Candey would take up to 50%, or to take 50% in this particular instance. And the reasons why, as we've set out in the skeleton, we say that this is important is because there is a dichotomy here between assignments to solicitors and assignments to non-solicitors in situations where the Trentex text, the test in Trentex, is satisfied by both. So the way that I put it in my skeleton is simply to ask the question rhetorically, what is the difference here between an assignment to a solicitor and an assignment to a non-solicitor? Where?
Well, I think that's one of the issues that we're going to need some assistance on in due course, because I don't think at the moment we are necessarily clear that Trentex is an answer to an allegation of champerty, even if it's not a solicitor taking the assignment.
No.
So that's something you will need to develop.
Absolutely, my lord. What I was proposing to do was, after going through some of the kind of broader policy decisions more quickly than I otherwise would have done, and then have a discussion, perhaps, and going through the authorities about the policy reasons which did exist to prevent these kind of transactions taking place, why those no longer exist, and we say because of the advent of contingency funding and latterly the advent of DBAs, which mean that there is no reason for those policy reasons to exist. And if those reasons then don't exist, then returning to my lordship's question here, the point being, is there any other reason why? And it may be, the answer is, as we say, it's not just a question of going through Trentex, but also looking at the solicitor-client relationship at that point, and concluding, as we do, that because the client has been advised to take independent legal advice, and because the nature of the assignment is no greater, or the value of the assignment is no greater than the client would otherwise have received under the terms of the DBA, then those two together then meet the champerty allegation. So effectively what we're saying is that if you have a situation where an assignment is given of a value of money, should we say, which is no greater than the value of money that the client would have received anyway, so the client is as well off, if not better, than the assignment than before the assignment. And secondly, the client has been advised to take independent legal advice. Whether the client does so or not, of course, is the client's prerogative. But the advice has been given, and in those circumstances, again, stepping back, the court may want to consider why, in those circumstances, the assignment shouldn't be valid. In relation to the documents, I think, your ladyship, you have them all, but just to orientate the court, the judgment is at tab 6 of the court bundle. There is a short chronology at tab 4, which sets out some of the procedural history.
Yeah.
You'll have seen it's quite a protracted procedural history, going to and from the Court of Appeal on a couple of occasions.
But
Yeah.
that needn't concern us.
Thank you.
The details don't matter. Personally, I found the chronology very helpful. Thank you. I had just one question. It really doesn't matter, but just so as I've got the picture clear in my own mind. In the county court proceedings, there was a notice of appeal filed against the judgment of Her Honour Judge Walden Smith, but I've been unable to discover what happened thereafter.
That I would have to take instructions. I think Mr Cohen may be better positioned because he was acting. The appeal was dismissed. I'm told that the appeal
But was permission to appeal ever granted?
Yours, my lady, I didn't appear in those proceedings, but I will try and find out.
I'm told the answer is no, and permission wasn't granted.
Right, I wondered if that was the case. Thank you.
My lady and your lordships will have read the way that we put the case in the skeleton, so I won't labour that anymore. There are a few additional points I'd just like to make, really by way of merits arguments. And developing the point about why should a lawyer in a damages sharing relationship be in any worse position than a non-lawyer? I rhetorically ask the question, well, if funders can take assignments, why not in that situation can't a lawyer? Secondly, why can't a lawyer then protect a commercial interest by taking steps which other ordinary commercial counterparties could have taken? There's also a natural access to justice point which arises, and it's this, that lawyers potentially might be much more reluctant to enter into these kind of relationships if they are worried that at some point in the future the client may become insolvent, they have no protection or they have little protection, or their rights are different from those of other commercial counterparties. And I say it's a natural risk or a natural access to justice point because it's obvious that if I can't protect myself when I know my client's going to insolvency, then I might be reluctant to take up those kind of difficult cases. And it reduces access to justice, where we know the whole purpose behind the CFA and DBA regulations is to improve and increase access to justice. Going to the assignment itself, or rather going to the circumstances of an assignment and comparing it to another situation.
Well, can I just ask you a question about that last point? You seem to be suggesting, I mean, I'm sure you didn't intend to suggest this, but let's be clear, that the interests of the potential creditors, of the potential bankrupt, don't enter into the equation? Well, is that correct?
Yes. In this sense, that's not an access to justice point. Nor is it a reason why we say the assignment should be invalid, because creditors of a potential bankrupt or of a company going insolvent or whatever in any situation are protected under the terms of the Insolvency Act. So if they think that any particular assignment prejudices them because it's an undervalue or is made a preference, they can then apply under Section 423 of the Insolvency Act for that particular assignment to be set aside. So they are protected. That indeed is a feature of this case, because the attack on the assignment was twofold. The first was the champerty attack, and secondly, there is a reserved position under Section 423 about the transaction being at an undervalue. And no doubt that if we were to succeed on the appeal, that would be the next stage, which was the next stage in these proceedings.
Well, I understand that, but, and obviously you're right to point out that there is a potential remedy under Section 423, but just viewing it purely in access to justice terms, I mean, why is it in the public interest to permit litigation to be pursued by people who can't afford to pursue it, if the consequence is that the adversary of the litigation is out of pocket, win or lose?
Well, the adversary isn't out of pocket, win or lose. The adversary in this case would have a different type of remedy, because if Mr Miller were to proceed and the matter went into bankruptcy in the normal way, then what would happen would be the bankruptcy pot swollen by the amount of damages. So he's not out of pocket. He would have to stand in line with other creditors. That's the difference. But we say the important feature of this case is that from the solicitor's point of view, because that is equally important when it comes to access to justice, the solicitor who's done all the work would suddenly find themselves in a situation where they are also a creditor, where otherwise they should have been paid.
This feeds into the point that you made earlier, that the position of the solicitors isn't in any way improved.
Yes.
They are in the same position as they were under the DBA, but that's not right. They're getting priority ahead of other creditors.
Well, they are getting priority in the sense that if the assignment is valid, then they are then the party who is running the case, and so they would be the party who receives its costs or receive damages in this case, first ahead of the other creditors. Yes, if there were other creditors, then that would be right. I mean, that is fundamentally the purpose of the assignment.
Yeah.
But I say there's nothing wrong with that, because that's the situation as any creditor where a client is potentially, or a counterparty is potentially going into bankruptcy. It's one of the examples that Lord Denning gave in, I think, Trentex itself, where he compared creditors in a normal situation. I'll take you to that later if I may. But he then said in Trentex that there was no problems there because the creditor, or rather somebody who is in this kind of relationship, which is about to go into bankruptcy, there's no issue there for that person to then assign the case to somebody else in light of a pending bankruptcy. So we say that solicitors should not be in any different situation to that.
But can you say that you're in no better position under the assignment than under the DBA? Because there's one big difference between them, which is the assignment covers £100,000 worth of costs in the county court proceedings, whereas the DBA doesn't.
Yes. There's two ways of looking at this particular assignment. One is from the client's point of view, and then the other is from the solicitor's point of view. In this particular DBA, the client does better. It also happens that the solicitor might also do better, and I accept that. But when one looks at the policy behind refusing the assignment, it is focused, I say, on the client, first of all. So if the client is actually better off under the terms of the assignment, then the fact that the solicitor might do slightly better doesn't really matter. Because the law in my submission shouldn't intervene in what is a commercial transaction here, for policy reasons, where the parties to the agreement both agree that they are better off by the terms of that particular assignment.
So
Yes.
if commercial judgment of the parties is the sole criterion, that's the end of the law of champerty.
No, because you still fall into Trentex. You still have to have the pre-existing commercial interest in the assignment itself. So it's not simply that they just agree to assign, but the law still steps in to prevent trafficking litigation, and we're not in that kind of situation here. There's no issue in this case that Candey had a pre-existing commercial interest. That was an argument which was going to be run at first instance. And
Only by virtue of the DBA.
Only by virtue of the DBA.
Yeah.
Yes. But it's not a point that arises in this case, because the Trentex test, we say, would be satisfied, but for the fact that the law of champerty looks unfavourably over solicitor-client relations in this kind of situation. If it wasn't for that, then we'd be straight into Trentex territory.
It's a strange position, though, is that if a statute has authorised making a DBA, your argument then is, well, it automatically then means they've got a pre-existing commercial interest which would justify an assignment.
Well, in this case, we're talking about two different things. The first is the DBA itself. It doesn't authorise the assignment, but it's a background feature, which means the client already has the interest by virtue of the DBA.
But will in every case.
That's
why my lord said authorises.
Yes, it's a precursor to the assignment. Yes, I take that.
Well, your argument is that to take something which has been expressly permitted by a statute,
yes,
but nothing else,
yes,
and then saying yes, but that then is the building block,
yes,
for saying that we can do something else which isn't permitted by the statute.
well, this is
that seems to be absolutely running a coach and horses through what Parliament's provided.
No, and this is Arnold as the second part of the appeal. We say that you can't simply look at the statute and say because statute has allowed a certain feature of DBAs and has regulated the client relationship in that narrow area, it means that it has therefore barred any other consideration of any kind of a related area. We say the authorities don't support that, and the textbooks don't support that either.
Well, it depends on the statute, doesn't it?
It depends on the statute.
There are cases where the statute occupies the ground, and then Parliament has legislated, and unless you satisfy the strict conditions, you're out.
You have to look at what the statute says in the area it's in. And we say in this case, the statute specifically regulated fee arrangements, which started off as CFAs and DBAs, and it said those are permitted. It didn't look at anything else.
Well, it says unless you satisfy the strict criteria, it shall not be enforceable.
Yes, yes. Of those arrangements, but we say that did not and does not mean that this court can't then look at other arrangements. And when it comes to those specific arrangements, which fall within the statute, of course, but when we're looking at other arrangements, it's a matter which is still open for this court to decide whether or not those other arrangements are permissible or not. I mean, our case on that is that when one looks at the regulations, yes, they do cover this ground. They don't cover the ground of assignments. And the argument which is made against me is that because assignments aren't specifically covered in the DBA regulations, therefore this court is unable to then look at whether or not assignments are valid. I say that's simply not right. It is still open to this court to look at an assignment separately in light of the public policy which arises from the fact that the DBA regulations were implemented as they were. And then, again, developing that, as I will do later, I say this, the DBA regulations allow you to have a solicitor to have a 50% share in a claim. Simply, that's what it is. They don't put any gloss on that in the sense that they don't require solicitors to take additional qualifications to look at conflicts of interest. They simply say that is the maximum that you are allowed. What does that mean to the previous authorities about conflicts of interest? Effectively, what Parliament is saying there is that were there any previous conflicts of interest, and there were the reasons why lawyers weren't allowed to enter into contingency fees, well, those are gone. You don't have to worry about conflicts of interest anymore, either because they don't exist anymore because we're a far more regulated profession now than used to be the case, or those conflicts of interest are now subservient to the points about access to justice.
Well, it's a balance, isn't it? Up to a certain point, Parliament's prepared to tolerate the potential conflict of interest, provided you satisfy the strict criteria within the Act.
Yes, yeah, Malay's absolutely right. And the number that Parliament has put on is 50%.
50% plus compliance with strict conditions.
Compliance with strict conditions. And the conditions in the regulation themselves are, it should be in writing, for instance, but there's no other condition or there's no other requirement that solicitors should protect the client in any other way. Simply, what Parliament has done there has come up with a measure which is a fair balance between the solicitor's interest, the client's interest, and access to justice. And it may well have looked at conflict in that circumstance, but the point is this, that if solicitors are allowed to enter into a 50% relationship, which they are, then any conflict issues which arise have been swept away. It doesn't matter anymore. They're allowed to.
An assignment is 100%.
Well, they might be 100%. In this case, it's not, in the sense that 100% goes and then the money comes back.
Well, no, the assignment transfers 100%
Yes,
interest.
it does. Yes, it does. But the effect of the overall effect of the assignment.
But it follows from your argument, as I understand it, that you don't say that it is a requirement that the assignment is on the terms that 50% goes back to the client.
Well, we say on the facts of this case, 50% goes back to the.
That's not what I asked you. You're saying your argument is that it can be 100%.
Well, there might be other cases where it is 100%. And that is where we get to the protection.
Well, it depends what the consideration is for the assignment.
Depends what the consideration is, absolutely. And then when one looks at what the protection is, and the first protection mechanism we say, which is relevant, is that there is a requirement that the client take independent legal advice. So take your lawsuits example. If there's something which was not quite right about the consideration, of course, if it's fair consideration, we say there's no issue anyway.
But what about Parliament's stipulation that the solicitor shouldn't take more than 50%? Again, you're riding roughshod over that.
Well, no, I'm not, because what we're doing is also protecting the case itself. So we're not just taking, suppose taking your example, there was a straight transfer, and there was 100% which went to Candey, and they paid 50% for it. The question in those circumstances is, should that assignment actually be championed as a matter of public policy? And we say no, it's not championed as a matter of public policy, because that is a straightforward commercial agreement with the protective mechanism that the client, for whatever reason, is allowed to do that as long as the client understands what the consequences are.
Yes, and on that, you have emphasised twice the role of independent legal advice, and that may be important. But can you just assist us a little on the facts there? The assignment itself records that Mr. Miller was advised to take independent legal advice, but is there any evidence that he actually did so?
No, there isn't. He signed it, and as far as we know, he didn't actually take independent legal advice, but he was advised to. The question then arises whether or not, I think Mr. Cohen footnotes it in his skeleton, actually you shouldn't enter into this kind of agreement until you know for sure that the client has taken independent legal advice. We say that sets a particularly high benchmark. Take the example like this of a commercial businessman who fully understands the implications of the assignment, and he knows what he's doing, or she knows what she's doing. And the lawyer then says, just to be sure, we want you to take independent legal advice. And the businessman or woman says, look, it's fine, I don't need to. That's their prerogative, absolutely their prerogative. It is to take the law a step too far to actually to impose a requirement upon that business
Well, why?
person.
So, for example, in the context of undue influence, it has to be affirmatively established that independent advice was taken. Simply telling someone you should take independent advice is not enough.
In some cases, yes. I mean, your lordship was talking about Ettridge in the cases.
Yeah.
Absolutely, in the cases around there. But take a different case, for example, of a businessman taking an assignment from their company. So it depends on the actual facts of the case. In my submission, that is a reason for the court to look at any particular transaction, but it's not a public policy reason why the transaction should be voided per se. So putting it like this, in my submission, assignments of this type should be allowed, or should not be disallowed because of champerty, but it is still open to the court to examine the particular assignment in question to see whether or not there are questions of undue influence. Because that happens all the time. There can't be a blanket ban in my submission over all assignments simply because there might, on an individual set of facts, be undue influence. The proper approach, I would submit, is that those assignments should be allowed or not prohibited per se. And if there are issues of undue influence, well, the courts are well experienced at dealing with things like that. So in your lordship's example...
So on that argument, would you say that there shouldn't even be any requirement that the client be advised to take legal advice?
No, I can see that in the case of a solicitor, because in the case of a solicitor, there is a specific relationship which pre-exists the transaction. It doesn't, so I can see why there might be a requirement. It's for your lordships, but your ladyship.
Well, I want to know what your submission is.
Yes.
So, are you saying, is it your submission that there is not even a requirement that the client be advised to take legal independent advice? Or do you accept that that is a bare minimum?
I do accept it as a bare minimum.
Right.
I don't think it's necessary in all cases, because in different cases the assignment may be much less than the value. The client does so much better under the terms of the assignment than he otherwise would have done before, or she otherwise would have done before. The question would then arise why independent legal advice was necessary. So the bare minimum, we say, would be the advice to take independent legal advice, not that independent legal advice ought to be taken, and you can't then enter into the transaction until that advice has been positively affirmed.
I can see that where a solicitor is entering into a commercial relationship with his client, that it would, I'd have thought in most cases, be essential that the client is independently advised because of the nature of the relationship which the solicitor has with their client.
the fiduciary relationship.
Yes.
In that situation.
And if they didn't, it seems to me they would be in difficulty overcoming some presumptions. But it seems to me that that has nothing to do with champerty.
No.
I mean, champerty is not the public policy against champertous agreements isn't predicated on potential unfairness to the assign-or. It's a wholly different thing.
Yeah, I mean, the way that we set out the appeal was exactly that. The question about champerty was a public policy issue, purely public policy issue, about whether there was a conflict of interest of solicitors entering into that kind of relationship. And previously, the answer was no, they couldn't, because that would effectively to allow the solicitor to have a commercial interest in the case, and that was prohibited for all sorts of reasons. We say that public policy has changed with the advent of the DBA and CFA regulations, and that is why we say assignments fall into a different category. What your lordship is asking is the next step in analysing it from a point of view of purity of justice and access to justice. Now, the way that I put it in my grounds of appeal is you don't need to go there. The judge went down that route, and he examined purity of justice and access to justice and balanced out left against right. I would say that's quite a dangerous way to look at it, because that involves looking at each separate transaction per se and deciding whether or not the pros and cons of that particular transaction increased or decreased access to justice. You don't need to go there. I know the judge did in this case, and we say it was wrong to do so. All that I say one needs to do and should do in this kind of relationship is to look at whether or not it is champertous, i.e. is there any public policy reason why this assignment should not take place in the context and in the background of the DBA regulations.
What your argument is and that is, you say there is a clear public policy, pre-existing public policy, to which Parliament makes some limited exceptions, and then you argue those limited exceptions have in some way changed the public policy. No. That seems to me that's a odd argument.
No, it's not that. We're not asking the court to make new public policy. And what we say is public policy has changed because Parliament has introduced these regulations. Public policy now is that solicitors are allowed to have shares of, effectively become an equal partner in a claim. That's what the public policy is now. So the issues...
Well, provided they comply with the requirements of the statute.
Yeah, that's in entering into fee arrangements, but one has to step back from that, because that, your lordship, is absolutely right. One looks at this specific fee arrangement in question, but what I'm asking this court to do is look at the consequences of that, because Parliament hasn't legislated in every single solicitor-client transaction. It has only legislated on that specific area about retainers between solicitors and clients. Now, had it been a comprehensive set of regulations or statutes or something and said that there was no other scope for any other solicitor-client relationship to be affected by that, that'd be one thing. But it hasn't said that. What Parliament has done has specifically said in relation to contingency fees and into DBAs, those are permissible. That's it. What it hasn't said is that every other species of champerty still exists.
But
this is a matter for the court.
They legislated against a background where it was clear public policy, the courts had set their face against assignments by solicitors.
Previously, yes. And this is in a way why we're here, because we say that shouldn't be the case anymore. Subsequently,
if you're right, wouldn't the sensible solicitors who are working on lots of DBAs, as a matter of, and as you say, the risk of insolvency is there. So why will they not, as a matter of course, ask their clients to sign a DBA, and then, as a matter of course, shortly afterwards, ask them to assign the claim instead?
Well, I suppose that the answer to that is that wouldn't be a real DBA. There'd be no intention there.
But that wouldn't matter, because your argument is that the public policy against assignments is now gone, so there's nothing wrong.
Well, in that situation, if the intention is to basically circumvent Trentex, as it would.
It isn't, because on your argument, they enter the DBA perfectly genuinely. That in order to get the commercial interest, both parties do that. It's a genuine agreement, and once there's a commercial interest, they then genuinely agree to assign.
Yeah, I do. I can see that.
And why wouldn't that become the standard practice?
Well, I mean, the answer to that is if it was genuine in both instances, then it might do.
But what does genuine mean? All they have to do is enter into an agreement that complies with Section 58AA, They then acquire the commercial interest that my lord has referred to, and they then enter into an assignment. Genuine has nothing to do with it. That will become the norm, and you say that's absolutely fine.
Well, I say that that is absolutely fine, because one still has to consider the genuine commercial interest in the assignment. And if there is, can I answer it a different way around? If the intention of the whole scheme was to circumvent the DBA and enter into an assignment straight off, well, that would not be permissible because there's no genuine intention there at all.
But where does intention come from?
Well, because then I'm just entering into just signing a piece of paper, which I know
You're saying it's
To
a sham. You're saying it's a sham.
that's a sham arrangement. So
Right.
I'd say, but that is certainly not permissible. But where in circumstances, and to take the point, if one enters into a DBA as normal, and there's nothing on, the DBA will continue. There has to be something.
What, enter into a DBA to obtain a genuine commercial interest?
Yes, obviously.
That-
That must be right. Obviously, that must be right.
So it's not a sham.
So it's not a sham. You're obtaining the interest.
It's only a sham if the intention was to immediately afterwards enter
Why?
into an assignment.
But why is that a sham? On your argument,
Because
you've
the-
obtained your genuine commercial interest, and you then go the next step to protect yourself against future potential bankruptcy or insolvency.
Because you're not you're obtaining the commercial interest with an intention to immediately divest yourself of it. Because what happens when you have the assignment here is the DBA is terminated. So effectively, you're entering into a DBA for the purpose of terminating the DBA. And I say that would be a sham arrangement because there's no intention to continue the DBA for any other purpose apart from termination. So you're artificially there creating a commercial interest rather than having a genuine commercial interest in the litigation. The commercial interest arises because the solicitor intends to carry out the litigation. That's what it's for. And if the solicitor's intention in entering a retainer is to immediately terminate the retainer, then not only is that not genuine, I'm sure there's all sorts of kind of professional ethics questions about whether or not you can enter into a retainer not intending to perform its primary function of litigation.
Well, this is an area of inherent uncertainty which arises from you using the DBA as a building block to an assignment.
Yes, yes, I absolutely concede that. And the point there is there'll be 100, 1,000, a million circumstances where this could arise, where assignments arise. The most common of which we've said was obviously the impending bankruptcy. And in those, what my lady and lords are talking about is a situation where solicitors deliberately, with no bankruptcy pending or anything like that, because if there's a bankruptcy pending, then that would be completely different. But there's no bankruptcy pending. They simply enter into a DBA with a view to taking assignments. And then I suppose the question is, well, why would they do that if actually they're not getting any more out of it than they would be anyway? There's a slightly odd situation or an artificial situation you're asking me to analyse because in practice, I don't really see when it would happen.
But if the client is about to go bankrupt and it's a good claim, then what's wrong with letting the client go bankrupt and getting the trustee in bankruptcy to pursue the claim?
Yeah, you're absolutely right. And one of the points that I make in my skeleton here is in this situation, why couldn't the trustee, if Mr Farrar had not sadly died and had entered into bankruptcy and the claim had vested in the trustee, what would have stopped the trustee simply assigning the case to Candey or selling the case to Candey? Now, in that situation, if I don't think there's anything in the insolvency legislation which stops that. Unlike liquidators, I think they have slightly different issues, but a trustee in bankruptcy can simply sell the litigation to Candey. Now, if the trustee in bankruptcy is allowed to do that, and then Candey is in exactly the same situation as if the claim had been assigned to it by Mr Farrar. It's very odd then, and I say inconsistent, that they are allowed to act had the claim been assigned by the trustee, but not allowed to act if the claim had been assigned by Mr Farrar before he became bankrupt. There's another point. I think it arises again. I can take you to this from Sibthorpe, where Lord Newberger quotes Wallerstein in one of the previous cases, not in the authorities, where His Honour Justice Simon Barker, sitting as a deputy, postulated a situation about people going into a joint venture and the claim being assigned to a joint venture partnership, and he didn't see any problems with that. And the analogy in this situation is this, that Mr Farrar finds himself into difficulty, Candey having run his case for a long time, one thing that he could have done, and His Honour Justice Simon Barker didn't have a problem with this, was set up a joint venture with, say, Mr Candey, not with Candey Ltd, with say, Mr Candey. For argument's sake, Mr Candey is 100% owner of Candey Ltd. So Mr Candey and Mr Farrar then become shareholders of a new joint venture. The case then is assigned by Mr Farrar to the joint venture. Now, where he and Mr Candey are equal shareholders. Now, if the court allows that, if the law allows that, so in that situation, it's simply an assignment to a joint venture partnership where the shareholders have commercial interests, pre-existing commercial interests, that would satisfy Trentex. So if the court allows that, because there's no champerty which arises, because it's not a solicitor-client transaction.
Yes, but again, you're making the assumption in that submission that Trentex is a get-out-of-jail card against any allegation of champerty, whereas I think that is an assumption that we need to examine.
Well, if Trentex merely says, what Trentex says is that as long as there is a genuine pre-existing commercial interest in the subject matter of the assignment, then the assignment is not something that will fall foul of champerty.
Well, we'll have to look at it. I'm not sure that is what it says. It certainly says that it's an answer to the problem of whether you can assign a bare cause of action. It also says it's an answer to maintenance. But certainly on one reading, it doesn't say that it's an answer to the problem of champerty.
Right. I take your point. I'll come back to that if I may. But if I just develop my example, and if we can assume, subject to going back to it, that Trentex is satisfied in the sense that the joint venture partnership, or the people involved in the joint venture partnership, do have a genuine commercial interest in the subject matter, which in this case they clearly do. It was Mr Farrar's claim, and he's a shareholder in there, so there can't be any Trentex problems with champerty in that particular transaction. If the subject matter is then assigned to the joint venture, then the other part of this case, the solicitor-client problem, doesn't arise, because you're transferring between Mr Farrar and a joint venture enterprise in which he has a 50% stake. So we can't strike it out for champerty, or can't strike it out for that reason. Next question, can you strike out for champerty? Well, certainly as against Mr Farrar, of course you can't, because it's his interest which exists in both of them. Subject to my law's point about whether or not Mr Candey would be caught by that, then the whole transaction would be okay. So in that situation, the joint venture partnership, of which Mr Candey is a 50% shareholder, is allowed to continue the litigation. But yet, the counterposition is that the assignment to Candey itself, of 100% of the claim, with 50% going back to Mr Farrar, it's not permitted. So there's a tension there. And I say that the law should be consistent in all of those. Because again, taking this matter in the round, maybe all sorts of ways, clever ways, far cleverer than I am, of a client protecting itself, or a solicitor protecting itself for the bankruptcy situation. So, as I said, it could have been a joint venture, setting up a company. There might be other ways, I don't know. But what Candey has chosen in this instance is to assign the claim with 50% coming back. Now, if there are other methods, and legitimate methods, of Candey protecting itself by setting up another company, then the question then arises, what is wrong with an assignment which actually has the same effect? So it's akin to the question of the trustee in bankruptcy. So if the trustee can assign the claim to Candey, and the Candey then carry on, then why on earth should it not do that by way of an assignment? What is the public policy reason here which is preventing that? And they used to be the public policy reasons, but it doesn't exist anymore. So what else is there which actually prevents the assignment? And what the judge has done in this case, and my lord, you are doing as well, you're pressing me on the reasons for the assignment, why it's good against bad. You know, does it improve justice, or does it somehow harm justice? Well, you don't have to look at that. You really don't have to look at that, because that is entering into very dangerous case-by-case territory. What one needs to look at is to see whether or not the assignment is simply valid. And the assignment is simply valid if the commercial parties have entered into it, and there is no other reason, there is no champerty's reason, traffic and litigation, for them not to do that. Champerty was all about, and this comes from Giles and Thompson and Lord Mustill's speech in the House of Lords in Giles and Thompson. Champerty used to all about very rich people bribing judges and bribing witnesses and and changing evidence. That was why champerty was in there. And there were the times when champerty was both a tort and a crime. Now those kind of issues have simply gone away. And actually, my lady, if I can just go to Giles and Thompson, I haven't looked at the authorities, and just go to that particular section, which is at tab 17 of the authorities bundle. Lord Mustill's speech starts at, in the authorities bundle, at 226. 153 internally of the case. So what, I'll read from it, if I may, into the record. What Lord Mustill says is that, my lords, the crimes of maintenance and champerty are so old that their origins can no longer be traced, but their importance in medieval times is quite clear. The mechanisms of justice lack the internal strength to resist the oppression of private individuals through such suits, fomented and sustained by unscrupulous men of power. Champerty was particularly vicious, since the purchase of a share in litigation presented an obvious temptation to the suborning of justices and witnesses, and the exploitation of worthless claims which the defendant lacked the resources and influence to withstand. The fact that such conduct was treated as both criminal and tortious provided an invaluable external discipline, for which, as the records show, recourse was often required. And then he goes on to this part, which my submission is relevant here. As the centuries passed, the courts became stronger, the mechanisms more consistent, and their participants more self-reliant. Abuses could be more easily detected and forestalled, litigation more easily determined in accordance with the demands of justice, without recourse to separate proceedings against those who trafficked in litigation. In the most recent decades of the present century, maintenance and champerty have become almost invisible in both their criminal and their tortious manifestations. In practice, they have maintained a living presence in only two respects. First, as the source of the rule, now in the course of attenuation, which forbids a solicitor from accepting payment of professional services on behalf of the plaintiff, calculated as a proportion of the sum recovered from the defendant. Secondly, as a ground for denying recognition to the assignment of a bare right of action. The former survives nowadays, so far as it survives at all, largely as a rule of professional conduct, and the latter, in my opinion, is best treated as having achieved an independent life of its own. And we say that he's absolutely right on this, because what he merely says is that you have two things going on here. The first is the public policy against contingency and DBAs. That's his first point. And secondly, it's trafficking in litigation. In our submission, the case here concerns the first point only. There's no allegation, or rather there's no sustained assertion in this case that we didn't have a pre-existing interest or Trentex wasn't satisfied. That wasn't argued below. So this whole case is, on the first point here, as a source of the rule which forbids a solicitor from accepting payment as a proportion of the sum recovered from the defendant. Well, that's gone. We're allowed to do that. So then the point is, well, if that has gone, then what's left? And in a kind of simplistic way, I say, if your lordships ladyship accepts that Lord Mustill was correct on that, and really what champerty is there for is to prevent the mischief which is caused by contingency arrangements. Now Parliament has now intervened to allow that. And what is the mischief which is caused now by an assignment? That's where I suggest and submit the court's focus should be. What is wrong with the assignment in this case? What is the harm in it? What is the public policy for preventing this assignment? And if there is none, and in my submission there isn't, because Parliament has done away with it, then the court needn't go on to consider whether or not the assignment itself is something which improves justice or causes issues. That would be to create a new brand of champerty in a time where actually the courts are asking champerty to withdraw its tendrils. The focus, in my submission, should be to make sure that champerty doesn't carry on. It's not extended. All the authorities go the other way, and I'll take you to them if I need to. We should be making sure that champerty doesn't have a hand to play in current litigation. It doesn't need to. Whereas actually, if your lordships and your lady, my lady, went down the route which the learned judge did below, we're increasing champerty by meaning that in every single transaction, not just assignments, every transaction which involves a solicitor or a client, one would then have to examine whether or not it promotes justice or inhibits justice. And one simply doesn't need that. That is not current policy. That is not public policy. It never has been public policy. Public policy is very clear, and is that which Lord Mustill says. It's very clearly designed to avoid trafficking in litigation. What this case has done is opened the door to some new public policy, looking at other transactions, which means that the court has to examine whether each transaction, whatever it is, again, I can't do every single transaction which the solicitor and client might enter into. I can only speak about the one beforehand. But there may be, again, an infinite amount of transactions which solicitors enter into. Now, is public policy in those cases going to be then just determined by examining the facts of each individual case and deciding whether or not it might improve access to justice or not? I mean, the difficulties can be seen in this case itself, because the judge had to micro-examine, for instance, whether or not there was some benefit to Mr Farrar in the money, whether there was some control which passed to Candey, which otherwise shouldn't have passed to Candey. So he looked at 4 or 5 factors. In each case, it's going to bring up hundreds of factors which the court would have to examine to see whether or not an assignment was valid or any transaction was valid. My submission, the court doesn't need to go down there because the established principles are well understood and well set out. The principles which are established are simply that lawyers should not get involved in trafficking, not get involved in contingency arrangements because of the conflict of interest. They have a fiduciary relationship with the client, and the conflict of interest is something which is there, right in the middle of that relationship, where Parliament has said that that conflict of interest is no longer something which is, as I said at the outset, either not important or it is something which goes into the balancing exercise in favour of access to justice. Well, public policy should reflect that. And so when one comes back to the assignment now, and says, well, what is the public policy preventing the assignment? Well, it's not conflict of interest anymore, because Parliament has legislated on that in that area. So DBAs mean conflict of interest in entering into litigation no longer applies. So what is left? My Lord, Lord Justice Arnold said, well, what about undue influence? Well, undue influence can occur in any case, in any transaction, in any fiduciary relationship. So it occurs between directors and companies, husband and wife, employee and employer. It's always there. The answer to that is not to ban all those transactions between those parties. The answer to that is to allow the transactions per se, or not prohibit them, and then look at the individual one. So if there was a relationship, a fiduciary relationship between an employer and employee where there was some kind of movement of goods between them, the answer is not to prohibit that per se. The answer is to actually see whether or not there's been undue influence. So we say, well, that is the correct approach here when it comes to assignments. The assignment per se should not be void, my submission, as a matter of policy. If it's to be voided because of undue influence, well, each individual assignment has to be looked at. In some cases, it will be blatantly obvious there's undue influence. In other cases, it's going to be blatantly obvious it's not. But the court shouldn't put a blanket ban over all of those and say, no, as a matter of policy, you just can't assign between fiduciaries. Because effectively, that's what the court is saying here. Because if solicitors aren't allowed to receive assignments as a fiduciary, then does that mean that employers can't transfer or enter into a relationship with employees? Perfectly proper, legitimate considerations, commercial relationships, can they not do that? Well, the answer is, of course they can. Can they not assign between an employer and employee or a company and its director? Well, again, it can, but there are other safeguards to make sure that you're not affected, or people aren't affected, or companies not affected. And that is the trend in my submission that is evident in all the cases against champerty. It's not to increase champerty, it's to decrease champerty to the extent, as Lord Mustill says, if it survives at all, is to decrease champerty and protect those who are affected through other mechanisms. And here, or in potential bankruptcy or insolvency of individuals or companies, the Insolvency Act gives appropriate protection. So had in this case, and it still may be the case, the assignment taken place at an undervalue, well, Mr. Miller will say, I'm a creditor, therefore set it aside, and everything rewinds. There's no mischief done there. But the mischief arises not because of the assignment itself. It arises because of the terms of the assignment, which the law is well capable of protecting through other legislation. And it does. It does it time and time and time again. So, again, rhetorically, why should the court intervene now to prevent the transaction? The answer is, if the transaction is a legitimate transaction, the parties are happy with it, commercially they're happy with it, it's not trafficking in litigation. If it's a fair transaction, then the court should allow it. If it's unfair, that is a matter for Insolvency Act, or going to the insolvency courts and arguing that, which again, I say may happen, but the protection is there. And if the protection is there against the mischief that the transaction causes, then why is the court now, why is the law now ready to intervene? To what end?
So we now need to probably go back to the two big ifs. First of all, has Parliament occupied the ground?
Yes.
And secondly, is Trentex actually an answer to the champerty point?
Yes. I will. Shall I start with Trentex? Paragraph 15. Sorry, tab 15 of the authority bundle. The first point about Trentex, of course, it's not a lawyer's case. It's a case between commercial parties and assignments between. I think ultimately ended up in some kind of sham assignment, which is why the House of Lords rejected it. But it was a case involving commercial parties, some of which had pre-existing commercial interests. Now, as regards lawyers, first of all, now I'll come back to non-lawyers. What Lord Justice Oliver says at, I think, 663F, he says there, there is, I think, a clear requirement of public policy that officers of the court should be inhibited from putting themselves in a position where their own interests may conflict with the duties of the court by the agreement. For instance, of so-called contingency fees. There may well be valid reasons why personal rights of action for tortious damages should not in general be the subject matter of assignment and partition, and or partition. So, to start off with, there's lawyers are separate. Lawyers are therefore separate. The question then arises as to whether or not, what one needs to actually satisfy the Trentex test. Now, I'm going to, if you could give me a minute while I find the relevant part, not just in the head note. What Lord Denning says starts at 164 internally, and sorry, the bundle, and 654 of the judgment. He says the old law has not been able to survive into modern times. That part of it has been questioned. But carrying on from there, because I don't think it's relevant to the next part of it. Going into 1655A, just as in maintenance, it is sufficient if the maintainer...
Where do you want us to read?
If you read the whole section from 164H to the end of the paragraph on the following page.
164H.
Yeah. So champerty today is affecting assignments.
Oh, that's one. Oh, right. Okay.
Sorry, it's page 654 of the judgment. Thanks. And 164 of the bundle.
Well, it's
165 of mine.
165 on mine.
Yeah.
Okay. Sorry. I've substituted one for the other. So.
How far do you want us to go?
Just to the end of that paragraph,
Right, yeah.
lady. So up to 16,
Yeah.
166C.
Yeah.
So Trentex then, Lord Denning is saying, is you're looking at a genuine interest in the subject matter of circumstances, and are they reasonable to warrant the assignment? And he says it's done on a case-by-case basis. So there's no principle to be drawn from that part of it. It's simply one looks at the assignment itself to see circumstances. And in this case, of course, we didn't have that argument below. We could have done, but we didn't. So it simply doesn't arise on this appeal. There's no broader point here in this appeal. There may be in other appeals, of course, I accept that. But in this particular appeal, that first part of it, the Trentex test, is not an issue.
You seem to be relying on that paragraph while ignoring the paragraph at the top of page 654, champerty today as affecting lawyers, which concludes with the statement, they are, emphasis in the original, contrary to modern public policy.
Yes, I'm not ignoring that at all, my lord. This is the whole point. This was the, I say the law, the common law. Of course, it's immutable, but this was the statement of the law as in 1980, and modern public policy there is in relation to contingency fees. So if one looks at continues there at 165C, the reason is still valid after the Act of 1967. I think we have that in the bundle. And he quotes Wallersteiner and Muir. It was suggested to us that the only reason why contingency fees were not allowed is because they offended against the criminal law as to champerty, etc., etc. I cannot accept this contention. The reason why contingency fees in general are unlawful is they're contrary to public policy as we understand it in England. And that's the point, because that's no longer valid. So that was public policy, a modern public policy at the time where contingency fees were not allowed.
Well, you have to persuade us that it's no longer valid.
Yes.
Right. Okay.
Yes, no, absolutely.
All right, but
That's a new
Yes,
study.
that is-
seem to be accepting that Trentex doesn't help you, whereas I thought your submission was that Trentex was the answer.
No. Trentex is the answer to assignments per se. This Trentex is what allows assignments to take place, because before
Not
Trentex-
involving lawyers.
Not involving lawyers.
Right.
So before Trentex, assignments were not allowed. It was after Trentex where the law was then refined to say, well, assignments in litigation, effectively as trapping in litigation before Trentex, not permitted. Trentex then came along, the Court of Appeal, and said, well, you are allowed this as long as you have a genuine commercial interest. So that changed the landscape of assignments. So we're starting from there. So assignments are allowed, but solicitors are still in a different category at this stage. Then
The solicitors, it's contrary to modern public policy.
it's contrary to public policy because of the conflicts of interest which arise. So solicitors are hived off, and other people, normal commercial transactions are allowed. So my point is that Trentex is an answer in this sense, because if there is no policy reasons why solicitors can't have assignments, then they fall back into Trentex. That's what
All
I'm
right,
saying.
but can I be clear what you're accepting and what you're not accepting? So, if I've understood correctly what you've just submitted, you say that Trentex disposed of the objection that it was an assignment of a bare cause of action.
Yes.
And I don't think there's any difficulty about that. But I understand you now to accept that it did not dispose of the objection based on champerty.
As regards solicitors.
All right.
As regards solicitors, yes.
Do you say it disposed of the objection of champerty as regards non-solicitors?
Yes.
All right.
It does.
Okay, and you will make that good, I trust.
Well, I mean, this paragraph does make it good.
Well,
In
after
the-
this is
sorry,
the Court
Moral
of Appeal,
Dennings.
we haven't even got to the House of Lords yet.
No. The House of Lords only touched upon the latter transaction, but in relation to the first transaction, Lord Denning here disposed of the champerty objection on the grounds that the maintainer.
Yes, but of course he was in the minority. The ratio of the Court of Appeal's decision comes from the judgment of Lord Justice Oliver, with whom Lord Bridge agreed, and he did not agree with Lord Denning.
Yeah, but on this point, my lord, this I don't have to just rely on Trentex. I can move on to some of the more recent authorities on assignments.
Well, by all means, but I thought Trentex was your sheet anchor, and I'm now confused.
No, Trentex is the answer to the question that if solicitors are allowed to enter into these assignments, then there must be a body of law which they have to comply with. And all I'm saying is that they are falling in line with the ordinary body of law, which starts from Trentex. And if your lordship has any points about Trentex itself, well, I say it doesn't matter for this reason, because the overall point I'm making is that solicitors then fall in line with other commercial parties. It's subject to, I caveat all of this with the point about there may be other commercial objections or other objections which are dealt with by the requirement to take independent legal advice. But if I put that aside for the moment, the independent legal advice point, then my submission is this, that if solicitors are allowed to take assignments, then they are no different to any other person taking assignments.
And you say it all starts with Trentex, but it doesn't end with Trentex. There are other cases.
But it doesn't matter what the actual answer is at that point, my lord, because
So you say that your reliance as Trentex extends this far and no further, that you say it establishes that in the case of non-lawyers, it's not an objection to an assignment that is champertus.
yes,
Is that correct?
yes. But
Now-
I take the point that that is not necessarily what comes out of Trentex per se, and it may have been developed later on in other cases. But I can meet that like this. For the purposes of my argument, it doesn't matter what the law of assignment actually is for non-lawyers in this sense, because there was no objection taken to the assignments in this case on those grounds. So in this appeal, we are
I
not
thought
looking
your
at
argument was the judge went wrong because he didn't apply Trentex, and you say he should have done.
No.
Therefore, we need to establish what Trentex is authority for and what it is not authority for.
That's ground one,
Yes.
as I understand.
that is the test he should have applied when looking at the assignment to solicitors. That's right. On the appeal itself, the Trentex point wasn't actually a point which was raised against me. It was abandoned, rather. I say it was raised and it was abandoned.
But you're relying on it. Your ground one says in terms that the judge was wrong not to apply the Trentex
Yes.
test.
I
Is that no longer
Well,
pursued?
it is. I mean, I think, in light of your lordship's comments, I'm going to have to think about this before I say anything further. I can come back to it. What the judge should have done is applied the ordinary law on assignments as applied to any other commercial party, which we say comes from Trentex.
Yeah, but that brings us round in circles, because you've made a submission about what Trentex stands for, although you then started to retreat from it. But I still haven't found the passage that you're relying upon as supporting that submission, because what you submitted, as I had understood it, has been clarified earlier, was that you say that Trentex establishes that it is no objection to an assignment of a cause of action to a non-lawyer, that the assignment is champertus, in particular because it involves a division of the proceeds of the litigation. And at the moment, I do not understand where you get that from in Trentex. I mean, in particular because obviously it's the House of Lords which matters for that purpose.
Yes.
And on its face, Lord Roskill at page 703 appears to say the opposite.
I'll start there, and then, my lord, I'll take you to factor tame after this, but
So just so as we're all clear what the question is, so this is tab 16 in the authorities bundle. It's 703 in the original report, 212 at the bundle, and it's at letter D. And he says, it is today true to say that in English law, an assignee who can show that he has a genuine commercial interest in the enforcement of the claim of another, and to that extent takes an assignment of that claim to himself, is entitled to enforce that assignment unless, by the terms of that assignment, he falls foul of our law of champerty.
So I see the point your lordship is making. So that this champerty argument lives outside the assignment.
Exactly.
Then the champerty argument, or the champerty point in these cases, is to do with the traffic of litigation. It's taking bare assignments. So what I think your lordship is driving at is to look at the assignment itself to see whether, irrespective of the genuine interest, there is another champerty's reason why it should not be permitted, or another reason which lies in the law of champerty. I mean, that's effectively, I think, what Lord Roskell is saying here. So going back to what Lord Denning said in the Court of Appeal, he looked at whether or not just whether they had an assignment, whether or not the assignment gave rise to a legitimate interest, but also whether the assignment was reasonable in the circumstances.
Well, one gets further elucidation at G. If the assignment is of a property right or interest and the cause of action is an ancillary to that right or interest, or if the assignee had a genuine commercial interest in taking the assignment, enforcing it for his own benefit, I see no reason why the assignment should be struck down as assignment of a bare cause of action or as savouring as maintenance. So, taking those two passages together, what he appears to be saying fairly clearly is that if there is a genuine commercial interest, that disposes of the objection that it's an assignment of a bare cause of action. It disposes of the objection that it's maintenance. But you still have to ask, is this champerty? And that simply involves asking, is it a division of the proceeds of the litigation?
Yes. I'm sorry, my lord. I hadn't understood what you were saying there, but yes, my lord, you're absolutely right. The argument about champerty and the difference between champerty and maintenance, we say changes because of the DBAs. So that has to be my answer, and it is my answer to the champerty point as opposed to the maintenance point. So I hadn't appreciated my lord was separating maintenance and champerty at that stage, but yes, now I understand. That is the answer, that the regulations allow champerty, whereas they didn't before. I'll just take.
That deals with Trentex. Now we can go to whether Parliament's occupied the ground. So, Mr. Hatt, we need now then to move to whether Parliament has occupied the ground or whether there is still scope for the comment.
Thank you, Ali. This is covered in my second skeleton,
Yes.
which is in the supplemental authorities.
Do we need to look at the legislation itself first, or will you take us to that afterwards?
I will take you to that in a moment. I can just find my place in my note. Right. The legislation is it's in the joint authorities under tabs, start at tab 4. So tab 4 is the CFA regulations.
Yeah.
Second, I'm trying to work electronically, so if you can Give me a page number would be helpful.
Page 8. I'm hoping it could be page 9.
It's the primary legislation, not the regulations.
I'm going back then to tab 1. So that is page, I think, 4. This is the 67 Criminal Act. I'll go through the legislation I made, and the primary legislation is the 1974 Act, which is under tab 2. That's page 6. So starting there, maybe page 6.
Page 5 in ours. Page 5.
Is it page 5?
Yeah.
Page 5. So page 5, yeah, contentious business arrangements.
So we're looking at section 59 of the Solicitors Act.
Yes. Subject to subsection 2, solicitor may make an agreement with his client as to remuneration in respect of any contentious business, providing that is done by an hourly gross sum or by a salary, etc.
And then 2A is the...
So nothing in the section shall give validity to any purchase or any interest. And all that means is that when one looks at the legislation, it doesn't validate anything which the common law says or doesn't say. It just leaves the common law as it is. It doesn't give validity to anything. So if the common law considers something as to be valid, then it remains valid. If the common law considers something to be invalid, then this legislation doesn't give validity to it. It just leaves it untouched. So in that way, it's neutral as far as the common law is concerned, in my submission.
Right.
Then the CFA regulations are at page 8.
Well, we need to look at the primary legislation first before we come to the regulations. I think page 8 is the primary legislation. It's the 1990 Act.
Yes.
Yeah.
No, I was just turning to that, the regulations, the 1990 Act. Yeah. So page 8. Which validates conditional fee agreements which satisfy various tests, or conditions. So section 1, CFA, which satisfies all of the conditions, shall not be unenforceable by reason of it only being a CFA.
So it's not that it's validating, it's saying it's not unenforceable.
It's not unenforceable.
So everything that isn't in there is unenforceable, or do you say? Yeah.
Then section 2, section 58, it goes through the definitions. A CFA is an agreement with a person providing advocacy or litigation services. It provides for a success fee, and the reference to success fee in relation are to be the amount of the increase. There are a couple of other requirements. So under 3, it has to be in writing. That's 3A. Certain proceedings which it didn't apply to, so it can't apply to those, and it must apply to any other requirements by the Lord Chancellor. And I think that's to do with the percentage of uplifts. So in this case, I think it varies between 100% uplift as beforehand, and it's changed recently as to whether or not you can get the uplift from the other side, but that's the subject of secondary legislation.
So that's 58 as originally enacted.
Yes.
Yeah.
And then the DBA regulations, which came in, I think, in 2013, are at page 13, the tab 5.
I think that's 58AA
58A.
as substituted by the, is it the 2012 LASPO?
That's right. So the same kind of stipulation, a damages-based agreement satisfies the conditions is not unenforceable by reason only of its being a damages-based agreement.
And then subsection 2.
Subsection 2. And the conditions are, well, subsection 3, it describes what a damages-based agreement is. A1, the recipient is to make a payment to the person provided services. The recipient claims a specified financial benefit in connection with the matter, so generally on success. And 3, the amount of that payment is determined by reference to the amount of that financial benefit.
And you say the assignment was in substance a damages-based agreement.
No, it had the effect of equivalent effect of the damages-based agreement. So
I think you say in terms in your skeleton argument that it was in substance a damages-based agreement.
I think I was loose there. I mean, what it means is the financial benefit of it was the same as it would have achieved under the damages-based agreement.
Why is it not rendered expressly unenforceable by subsection 2 of section 58AA?
The assignment isn't a damages-based agreement because it's not an agreement to provide advocacy services, which is a condition under 3A.
Right.
And the conditions which are then satisfied are 4A, it's in writing. And the regulations then prescribe that no more than 50% should be the recovery under the damages-based agreement, and the DBA complied with that. And I think we have two regulations or 2 statutory instruments which then are applicable under tab 7, that's page 33. That was the success fee for CFAs at 100%. And just over the page, at page 34, these were the 2013 regulations. And at 4.3,
I'm sorry, which page are you on there?
page 34, my lord.
34, thank you.
So at 4.3 we get the cap on the amount of damages, which should be no more than 50% of the sums ultimately recovered by the client. And the agreement in this case met those requirements, so there's no issue about that, and allowed Candey to take 50% of any eventual recovery. What it may be sensible if I take you to the assignment at this stage, you can see the difference between the assignment and the DBA. And that is at page 110 of the core bundle under tab 11. And at the same time, if I could ask my lady and your lordships to turn to my skeleton at page 32, so the very last page where you set out a tabulation of the difference between the DBA and the assignment. So there's an assumption of a judgment sum of 1.3 million. That's in Mr Single's reference. Of course, it's disputed, but as a starting point, that's what we say. Under the terms of the DBA, Candey would have then taken £650,000 first. £200,000 estimate of costs returned by the defendant. And we estimated a funding requirement of about £50,000. Again, it's all estimates, of course, and best guesses, but ultimately in that scenario, the estate would have received £800,000. So, under the terms of the assignment,
So where does this table take into account the £100,000 for the county court costs?
I will have to check that. I think they're separate. Do I take instructions on that? Well, that's all captured in the 50%. So the £100,000 falls within the 50% recovery. Well, do I just take instructions on that? Excuse me, I'll just take instructions on that point.
But, I mean, the arithmetic is mystifying. I mean, footnote 9, I don't begin to understand what those figures are.
Yes, I will tell you where the figures are. Take instructions on the first
Because,
point.
you know, one looks at 3.1b of the assignment. So after the ATE comes off first.
Yes, that's the 156,000.
All right. But then it's a sum equivalent to double actual legal costs, past and future. And of course, as at the date of the assignment, we know the past costs are 135. We don't know off the face of the assignment what the future costs are. And then you add on what's called the other litigation hourly rate costs, which we know is the £100,000 for the county court litigation.
Yes.
And then there's a cap of 50% of the recoveries. So this table proceeds on the assumption that the 50% cap doesn't bite, but it's completely mystifying to me as to why not.
Well, so I take instructions.
All right, so I think I've worked it out, hearing what your June is saying. So as I understand it, the answer is that if we look at footnote 9, the 156,800, that's the ATE.
Yeah.
The 125 is the figure that is mentioned later in 3.1b. So hence you take the 1.3 million assumed recovery, you first take off the ATE, you then take off the 125, you then apply the cap of 50%, and that's how you get to the 509,100. Have I got it straight?
I think you're right, but I'm not going to.
Yeah. All right.
Yes, that's clearly right. Yes, thank you, my lord. There's just one further point I'm just going to clarify.
So the county court costs have gone up to 125.
And the £100,000, my lord, falls within the clause as well under the assignment. So it's all there within 3(1)(b) as the
Yeah,
litigation
but
costs.
I mean, in terms of what the economic effect of all of this is, it all depends on what the costs are in pursuing this claim. Because you know, if, for example, there's further costs of another $500,000 to be incurred to pursue this claim through to judgment, then Candey suffers a loss either way. Whereas you get a rather different result if, say, it's just another 100,000 to pursue it to judgment.
Yes, my lord. But if it's successful, then the money comes back on the cost paid by the defendant in both cases. Because that's a debit on both sides. So I don't think that is going to affect the relative outcome between what you would get, whether the DBA is better than the assignment or not.
Well, subject to the effect of the county court costs.
Subject to the effect of county court costs. Yes.
Yeah. Was there any evidence before the judge as to what the projected costs were?
Only Mr. Singleton's estimate,
And what was that?
it was £200,000, and it is.
Can you show us that, please?
Yes, I'm about to. It's in his first statement.
Tab 14.
Tab 14. Thank you, my lady. It must be in the second statement, which is tab 18. Take instructions again.
He says the value of the claim is in excess of 1.6 million, so why are we taking the figure of 1.3?
What's the conservative estimate?
Okay. So where does he give us the costs estimate?
I don't think he does.
I don't think he does, my lord.
I've looked at both witness statements. I don't think he does in either.
I think you're right. There is no.
Right. So no evidence before judge as to future costs.
But the point I made earlier still remains the same. It's a debit on both sides, whatever it is. So the comparative, the comparison remains the same. If you just take it off both sides, so whether it's 100 or 400, it doesn't matter.
Right, so that's the economic effect. Was there anything else you wanted us to look at in terms of the deed itself?
No, I don't. So the point, my lord, to take out of that is that, relatively speaking, and accepting that there is no evidence on the amount of cost, but relatively speaking, whatever those costs are, Mr Farrar would have been better out of the assignment than he would have done out of the terms of the original DBA, whatever the number is. Okay. Then to move on to the point about where the common law goes in light of statutory developments, we have in our skeleton cited President Burroughs' article on this, and if I could ask you to turn to that, because it helps me summarise where, in my submission, the law ought to be. That's tab 6 of the Supplemental Authority Bundle, page 450. He specifically talks about freezing the common law at page 462, at internally page 244. And so if I may ask the panel either to read this now or read it later, depending on which way you want to go. But the summary that I want to take from it before one reads it is at page 465. So halfway down, the picture emerging, therefore. And he says there, and I will read this part out. The picture emerging, therefore, is that while some judges have felt able to reject the argument that a statute precludes development of the common law, others have found that argument persuasive. It is submitted that the better view is that the passing of a statute should rarely be viewed as blocking a common law development that the courts would otherwise like to make. It is a myth to think that by passing a statute, Parliament has positively decided that what would otherwise be a legitimate common law development should not be pursued. Parliament is most realistically regarded as having no view, let alone a negative view or on a common law development. If a gap has been left, that may have been by oversight, or it may have been felt that the courts could deal with any further development, or it may simply have represented the priorities as Parliament saw them at the time. The search for some sort of parliamentary intention is misguided. The real question, which is for the courts to determine, is whether the proposed development would be inconsistent with the statute by undermining it or making it unworkable. And he carries on, it's worth interjecting that once one appreciates that it's rarely legitimate to argue that the existence of the statute precludes common law development, judges ought to exercise extreme caution before relying on the argument that the possibility of a statute being passed in the future should preclude common law development. Yet there are many examples of judges giving this as one of the reasons for not developing the common law, that is something best left to Parliament. And moving on, even if legislation was thought more appropriate than judicial law reform, provided that judges are deploying traditional judicial reasoning, determining the rights of the parties before them, rather than making a wide-ranging policy choice, it's hard to see whenever this should be so. We all know that it is hopelessly unpredictable whether Parliament will intervene or not. To hold back a development on the basis of a chance that Parliament may intervene represents nothing less than an abdication of judicial responsibility. Better it is for the court to proceed, knowing that of course the legislature is always free to impose a statutory solution or amendment if the common law approach is thought unsatisfactory or incomplete. One suspects that deference to possible legislation is often being used as a make-weight argument by judges who, for other good reasons, do not favour the development in question. If so, that is disingenuous. Judges should decide on reasoned grounds whether they favour a particular development of the common law or not. It would be rare, if ever, for the possibility of legislation to add anything of substance to the case against development. And
that's an extraordinarily high level of abstraction.
yes, but
And it, my immediate concern about it is that how often are we sitting here consciously making developments to the common law? Because primarily what we are bound by is the common law as it is perceived by previous decisions.
yes.
So that the circumstances which we are consciously not only going to but able to make a development are quite limited.
Yes.
I think at the moment I'm slightly struggling to see where the development comes here. And that's no doubt where you're going to take us.
Well, again, the development arises here because of the introduction of the DBA regulations in 2013. And because Parliament there has changed or has permitted something which otherwise would have been prohibited. And then the question becomes, is the common law then influenced or affected by that change of parliamentary intention?
So you say because the DBA regulations permit a certain form of DBA, we should permit the assignment because it would not be inconsistent with the statute, it wouldn't undermine it, and it reflects a trend towards reducing champerty wherever possible.
Yes, my lady, that's right, because what the common law, what Parliament has done by removing any bars to sharing the spoils of damages is allowed, I say, law now, or it's given a path to the common law to now develop to reflect that change. So if one takes the view that because Parliament now accepts, the legislation now accepts that lawyers, there is no problem with lawyers entering into this kind of agreement, so the issues which used to be there no longer exist, then that opens the door to the common law to consider those same kind of policy situations in other points.
But if we take the view that it would be inconsistent with the statute and it would undermine or make the statute otherwise unworkable, then we don't go anywhere near this.
No, absolutely not. Absolutely not. But what my learned friend's argument is, and what the judge said, was that because Parliament has intervened to this extent, then you can't even, that question doesn't even arise. And they are saying that because it intervenes in this narrow question about whether the lawyers are allowed to take 50% of damages, that's it. It is not open to the courts then to look at other areas which might be affected by it. Because the argument goes, it's the one that Professor Burrows strongly disagrees with. The argument goes that Parliament would have intervened in this area, wouldn't it, if it had really intended to do so. That's not right, because, as it says, where Parliament intervenes may be dictated by any number of circumstances and priorities. Just because they haven't chosen to intervene in a certain area, in this case assignments to solicitors, doesn't mean they prohibit it. It simply means that that legislation doesn't cover that area. If it doesn't cover that area, so it's not inconsistent with it, then in my submission it's open to this court to decide whether the common law should now reflect what is clear is Parliament's intention.
Just as a matter of chronology, this article, of course, is dated
Before.
2012,
Yes.
April 2012. I don't recall off the top of my head, but when was the decision of the Supreme Court in the Nicklinson case, which might be regarded as an interesting test of his proposition at 248?
We'll find out. Let me talk about it.
Doesn't seem to be referred to, so I'm guessing it was later.
2015.
Right.
Tab 4 in that bundle.
We check on that. We think 2015 may have been the Court of Appeal decision.
Okay, so the Supreme Court would be even later then.
Yes.
Okay.
Can I ask you one just pragmatic question about how the assignment works. As I understand it, the 50% is a cap,
Yes.
and it's dependent upon what the assignee is actually entitled to are future costs incurred at standard terms of retainer. How do Candey actually? How are those costs actually incurred if there's no client? I mean, who's billing who?
Yeah, I understand the point. I think the assumption would have been that Candey would have done the work, but
And they bill themselves.
they could build themselves, or they could instruct somebody else to do the work for them. So as soon as the assignment has taken place, of course, then Candey no longer is acting as a lawyer; he's then acting as the person who is the owner of the assignment.
Well, except that the hourly rates are as per Candey's standard terms of retainer.
Yes. No.
And the assumption here is that Candey will continue to do the legal work.
It is. I mean, it is the assumption. It's not. I say it's a matter of interpretation of the assignment. Candey doesn't have to do the legal work. But I think you're right. That was clearly something. That was clearly what would have happened in practice.
But those costs wouldn't be liable to any form of. I mean, if the Mr Farrar or his estate wish to challenge that, they would have to do that in a dispute over the application of this agreement.
Yes. If there was first of all, the costs as between Candey and Mr Miller would be subject. If Candey won, would be subject to assessment. One assumes.
To be sure, but it's the solicitor and client
Yes.
costs.
Yes. No.
And since Candey would be acting for itself, there wouldn't be any room for control under the 1974 Act, would there?
Not if Candey were acting for itself. But in that situation, there's Candey as the assignee, commercial assignee, and then Candey as the lawyer in the litigation. So it is wearing two hats at that point. Because so you take the situation where Candey instructs another firm of lawyers then to act in the underlying litigation. Candey itself would not have any costs then.
But it wouldn't have. I mean, the whole point of this would be utterly destroyed if Candey would instruct somebody else and be paying them.
The answer is it might be, but the intention clearly was for Candey to act. Just talking hypothetically, if Candey didn't act and instructed somebody else, then there would be different numbers under the assignment. But yes, I have to concede you're right. The answer would be the challenge of the assignment.
But it's dressed up to make it look as though.
Sorry, Arnold. I think that must be right. I think Junior says that because it's Candey's retainer rates, the assumption is that Candey are going to act. I can't take it any further than that.
Well, it says it's more than this. It's incurred pursuant to the assignee's hourly rates.
Yes. I suppose you could argue the cap of that rate, but
Well, then there'd be absolutely no benefit to Candey at all in contracting this out to another firm of solicitors and paying them Candey's hourly rates.
it
The whole thing would become
No, it would.
a complete economic nonsense
Yeah,
for them.
no, you're right.
They make no money at all.
They wouldn't make any money at all.
Well, more than that,
Unless
no, because they could all they can recover are the fees,
Yes.
and they'd be paying somebody else the fees.
Yes. It might be. That's well. Then the implication must be that Candey would have done the work itself.
Yeah. But that's an odd aspect of this, isn't it? That what it ends up with is that the client is that the solicitor effectively deducts from the sum that goes to the client its charges, but the client has absolutely no visibility or right to control those costs. I mean, it's turning the DBA on its head in a way which means that the former client no longer has any of the normal protections and is exposed to effectively the uncontrolled whim of the solicitors as to what they charge in the litigation.
In theory, but it's still controlled by the solicitor's code of conduct. So that's always a risk. That solicitors one has to assume that solicitors will act honestly and within their code of conduct and will not overcharge or overbill. So what the scenario...
I wonder what the chances are that it was going to come out at less than 50%.
Yes, but on a normal solicitor and client assessment under the Solicitors Act, the solicitor is limited to what's fair and reasonable. It's not the same test on a party and party assessment, but nevertheless, there is a court control of what the solicitor can charge. Whereas my Lord's question is that appears to be absent here.
Well, there's no express control, yes, I accept that.
Well, it's not merely that there's no express control, which is obviously correct, but I think you've already accepted that the statutory mechanism is excluded because solicitor and client are one and the same.
Yes. I mean, this is no longer a fee agreement. So any statutory provisions which bite on fee agreements just don't bite on the assignment.
Yeah.
Does Candey actually bill itself? Do they actually raise feelings?
That I would have to take instructions on. Can I just go back? I'm not sure it's an answer, but I'm told law firms act for themselves all the time and recover their fees. So whether one needs to bill, whether the law firm needs to bill itself or not, I'm not sure. I'm not sure it really matters.
I see. Thank you.
Right, so where I was the question of we're still back on the common law and the extent to which the court could apply the common law where Parliament has signalled an intention to move in a different direction. And to conclude my submission on that particular point, I say that one has to look at the direction of the common law to see whether it is inconsistent with where the statute has trodden. And if there is no inconsistency there, the direction of common law should therefore reflect what public policy should be drawn from the way that the statute was enacted. So in this case, the statute was enacted to allow solicitors to enter into these kind of arrangements. There is nothing inconsistent with that in allowing an assignment to take place, which has the effect of being that solicitors can take a share of the proceeds. There's no difference in practice. And again, it goes back to the same question, really. What is the public policy mischief which the court is trying to protect here? If it's not a conflict of interest, then what is it? The court is saying that this assignment should not take place, or any assignment should not take place. But this assignment in particular, what is the problem? And my submission, there was nothing in the court below, the judgment below, which identified a problem with the assignment per se, save for the fact it was just between a solicitor and client. And once one has got over that, we say you get over that because of the DBA regulation, there's no conflict anymore, then there is nothing outstanding unless this court and my lady, your lordships, wish to increase the preponderance of champerty. And my submission, you shouldn't do that. There's no reason to do that. There are other control mechanisms.
Well, as I say, whether you say that the legislation provides two aspects which combine to make your case. One is it shows that that a sort of fundamental underlying policy no longer applies. But secondly, it provides the ability for a solicitor to gain a commercial interest, which then renders it possible to argue that on established principles, the solicitors can take an assignment.
Yeah.
So it's both of those things that you need the legislation for.
Yeah, I think the second one probably follows from the first one, because we say as soon as you've taken away the CFA issue, the conflict of interest issue, as soon as that goes, because public policy no longer deems it inappropriate for solicitors to have some kind of share of proceeds, then you get to the second question, which is whether or not they can then take a commercial interest. So I think we'll have to go to the first one to get to the second one. I can't.
But solicitor can only get the commercial interest, can't they? Through the DBA or the CFA.
Yeah. But there has to be something. I mean, there has to be. So, as I said at the outset, I mean, there may be other agreements which they enter into. I can't go into those, but any other solicitor-client agreements in different areas of law. But we are simply talking about the assignment of a cause of action. But yes, the interest arises because they previously acted under a DBA.
I can't, off the top of my head, think of any other way they could get a commercial interest.
No, I'm just thinking about different areas of outside litigation, perhaps. I mean, we'll think about it, but certainly in the litigation area, it can only be one that arises out of a previous retainer. But I suppose if a solicitor was taking part in a conveyancing transaction, and then the solicitor himself or herself decided that they wanted to buy the house, that might be a question which arose. So, and if in that situation, what would the safeguards be when you have fiduciary duties, or would a solicitor never be allowed to buy a house, or is the answer that the solicitor would then ask the client to take independent legal advice or independent advice about whether or not the solicitor wanted to purchase the house? I'd be surprised if the law was that the solicitor can never purchase a house for a client. But it makes sense for there to be some kind of safeguards to make sure the client wasn't being taken advantage of. It could be something. Let's say here, the point is that the law against champerty was directed towards a conflict of interest, so that conflict of interest. So taking the house example, if Parliament had legislated to say, for whatever reason, that was fine, because solicitors are allowed to buy houses, then one could then use that particular principle and apply it to other solicitor-client house transactions. That's what we're asking to do, because as soon as the Parliament says that this is all right, that there is no conflict of interest, or the conflict of interest is subservient to access to justice in those situations, then the assignment itself can't fall foul for the same reason, or shouldn't fall foul for the same reasons. And there are two cases. There's one case my learned friend relies upon. It's the case of Fender. It's the court, his proposition that the court should not develop the common law. That's at tab 14 of the Joint Authorities bundle, which is at page 84. It's a case in different times. And the question was whether or not it was against public policy to enforce a promise to marry when the promising man had been separated from his wife, but the divorce hadn't been finalised. So, tangential relevance at all. But what your lordship and my lady will see from page 12, which is 95 of the bundle.
It's sidelined on 93 and 94.
Yes, it is. My page number has gone completely awry on this. Yes, if your lordship's my lady would quickly read that, but I'll summarise it. He simply says that contracts should be given the benefit of the doubt where there are unclear public policy objections. I think I can do better than that.
Yeah, well, that's the passage that is at the top of page 12, which is page 90.
Yeah. And then if I could ask my lady, my lords, to read, we'll turn to page 104, 21 internally.
Sorry, what was the page number?
21 internally, page Z104, about halfway down. It starts on the right-hand side, so not in the first big paragraph, in the second big paragraph, about 10 lines down, it appears to me.
Yeah.
It appears to me wrong to assume the doctrine of public policy applies to any case of class of contract without regard to the public mischief on which the decision or decisions are based. I point out all material circumstances which lead to mischief in this case are absent at present. And then goes on, I do not myself understand a doctrine of public policy which is merely founded on a statement that one contract is inconsistent with or incompatible with another. Then just say the doctrine is unmeaning. Doctrine is unmeaning unless the impugn contract leads or is likely to lead to an injurious action. And you can see echoes of this, I think, in the submissions that I make, and it's that unless one can clearly identify the public policy and then translate it into the effect it has on the assignment in question or on the matter before the court in question, unless one can identify something which is injurious to the public, then the contracts ought to be allowed to stand. Could I next ask, we've cited Hall and Simons, so that was the barrister's immunity case, which I don't think I need to take you to. But if I could ask my lady and my lords to turn to Zuberi, which is at tab 22 of the authorities. This is a case which directly concerns DBAs. Sorry, page 323.
Thank you.
Sorry, my lord. This is a case which expressly concerns DBAs, and that was a DBA in which the solicitors had inserted a term which allowed them to terminate, or allowed termination, and then it allowed them to recover their fees if termination took place. That was something which wasn't expressly permitted under the DBA regulations. So they are now treading the line outside and have done something which Parliament has not expressly sanctioned, but nor has it inhibited. It's simply silent. And that was permitted in this case. And there are echoes of what Professor Burrows says at paragraph 31 of the judgment. And there, Lord Justice Lewinson says that, of course, Parliament may abolish, modify, or displace any common law rule. There is a general assumption that it did not intend to make changes to the common law expressly or by necessary implication. In considering whether a statute, quotes Benyon, cites Benyon, in considering whether a statute has displaced the common law, the court must consider the extent to which a legislative purpose would be undermined by the continuing existence of the common law operating alongside it. Where a legislative scheme is comprehensive, that may be an indication that common law has been displaced. So I do rely on that. I mean, from the other way around, one, as my lady says, one looks at the statute itself and sees whether or not it is comprehensive or not. And if it's not, then the common law subsists around it. I think in Professor Burrow's article, it talks about oil and water and the historical tendency for people to think of oil as common law and statute as being separate. And he said, well, it's not that at all. Because statute is statute, and you have to read them together. And where statute gives space for the common law to exist, which it does, then it's up to the courts not to be afraid of determining what the common law should be, and what the statute says.
But forgive me a bit. And one way of looking at it is we have very clearly established common law principle, recognised in more than one House of Lords decision, that it is that an assignment to a solicitor, assignment of a cause of action from a client to a solicitor is unlawful. And the statute has not impinged on that in any way. It doesn't deal with assignments. It doesn't say they're lawful. So how one construes out of a limited legislative permission to have conditional fees and DBAs into rendering assignments lawful seems to me to be quite a stretch.
Well, my lord, the point is that it isn't a stretch when one understands what the regulations have done, what the 2013 regulations have done, because they have ridden Cochin horses through that entire area of common law.
Well, they've made very specific very specific regulations as to ensure that the client is protected and that the solicitor isn't given carte blanche as to how they deal with these agreements. And one of the things it doesn't, for example, as we've looked at, it doesn't permit solicitors to do is effectively to charge fees on a completely uncontrolled basis.
I mean, where Parliament's intervened on, you're absolutely right, Lord. Where Parliament's intervened is on the amount that can be recovered. It hasn't touched upon any other conflict of interest points, which it could have done. I mean, take when barristers were allowed to enter into direct agreements with clients. A whole raft of legislation or requirements which then grew about taking 20 hours of courses and all of that to make sure that barristers were cognizant of their duties to the clients. Nothing like that in these regulations. So all the regulations have done is said that you can enter into these kind of agreements. We are not imposing any other training or professional or any other requirements on you whatsoever. We're simply saying that if you do enter into these regulations, you can't take more than 50%, as long as it's in writing, etc., etc. So that's it.
All right,
So,
but could I pursue my lord's question in this way? One could postulate three different types of objection to the assignment in the present case. Objection number one could be it's an assignment of a bare cause of action. The answer to that objection is Trentex, because Trentex tells us that you can assign a bare cause of action if there is a genuine commercial interest. But it says that's subject to the question of champerty. So objection number two is this is not just an assignment of a bare cause of action, it's an assignment of a cause of action to solicitors. Now, what Mr. Cohen says in his skeleton argument is that the case law establishes, and Section 59.2 of the 1974 Act confirms, that there is an absolute prohibition upon assignments to solicitors of causes of action where they have been acting. And he says that's independent of any question of champerty. So let's park objection number two for the moment. Then objection number three is, then there's the question of whether the particular assignment is champertous. And he says it is, because it provides for 50% of the proceeds to go to the solicitor. Now, your argument based on the statute is potentially an answer to objection number three, because what you say is, well, the statute shows us that it is not inherently objectionable for solicitors to be permitted to act in circumstances where they receive, instead of hourly fees, up to 50% of the proceeds of the claim. But what about objection number two? Why is it this an answer to objection number 2?
Well, it is an answer to objection number 2.
But why, when it says nothing about assignments?
Because it is silent either way. Section 59.2 does not validate or invalidate anything. It's silent on assignments. It doesn't mean that solicitors can't enter into assignments. It doesn't say anything about it at all.
No, but the pre-existing common law is you can't.
Yes. And
So you have to persuade us that the statute somehow changes the pre-existing common law.
yeah, I do, and I go back to what Lord Mustill says in Giles and Thompson there, because the whole reason why the common law existed at that point was to prevent the mischief which was inherent in contingency arrangements. Going back to what the problem is, it's a conflict which arises when lawyers get involved in litigation. So the historic reasons, we put them in our skeleton, were to do with suborning witnesses and justices and tampering with evidence. That is why solicitors were not allowed to enter into these type of agreements, because that was the risk. What the 2013 regulations have done, preceded to some extent by the CFA regulations, is allowed that to happen. Because what is Parliament saying there? It is saying that not only are solicitors, what Parliament is saying there, solicitors are now allowed to take a 50% share in cases and run the case. So when one looks back, because that's what's happening here, so a solicitor is effectively a co-partner in a case. It's a commercial co-partner. It is an equal share in the outcome, or up to an equal share in the outcome. The historic problem with that, and the reason why it wasn't allowed, was because solicitors were in a position to influence or ask witnesses to perjure themselves, suborning, or tampering with evidence. So first of all, that's pretty unrealistic.
Right, so as I understand it, your answer to the question I put is to say, well, the logic is the same, because if you're going to allow, as Parliament has allowed, solicitors to act on the basis of 50% recovery of proceeds, then that is inherently tolerating a conflict of interest. And if you're going to tolerate a conflict of interest in that scenario, it's no different if it's an assignment.
Absolutely our case. That's always been our case. Absolutely that. And that is why we say the common law can develop in that area, relying on what Parliament has done.
Well, the big difference is that under a DBA or a CFA, the client remains the client, and the solicitor owes duties to the client. Whereas under the assignment, the solicitor-client relationship is gone. So thereafter, the solicitor is pursuing this cause of action that it has purchased entirely without needing to take into account any interest of the client.
Well, the client's interests are happily aligned with his own in terms of maximising recovery. But, so there shouldn't be an issue there anyway. But Lordship, it's right that the solicitor...
Not in terms of the amount spent on the claim.
Again, I mean, you're then talking about a solicitor who is acting outside his code of conduct and just billing or overcharging or whatever. That's a different thing entirely.
Well, no, there may be decisions to be made as to how to conduct the litigation,
Yes.
which the client would have be able to give instructions on, and he might take into account the cost of so doing. You'll have no such input.
No,
Under the solicitor will conduct the litigation exactly how they see fit, and will be able to take steps which perhaps would not be in the best interest of the client because they would be too expensive, without any concern, because they will benefit from doing so.
yeah, and the answer again to those kind of points is the requirement, I say, of the client to at least take the advice that the solicitor gives, which is before you enter into this assignment, go and get a check.
That doesn't in the slightest answer the concern that one might have as to the change from a solicitor-client relationship to a mere contingent creditor. The fact that you've been advised that it might be in your interest to do that doesn't change the public policy concerns that something is being allowed here, which on the face of it is contrary to existing public policy and which is not the same thing at all in these respects as that which Parliament has permitted under the legislation we've looked at?
Yeah, to kind of unpack that a little bit. There's two things. There's the first, whether in principle these kind of arrangements are allowed, permissible or not, and then secondly, there's a question about the individual arrangement and whether or not that is then somehow offensive to some new principle or some different principle of overriding justice. So, and the way that I was putting it earlier, and I accept that, is that the courts should, in my submission, allow those assignments which, on the face of it, do not offend justice. But if there are individual issues with any particular assignment of the type that your lordship raises, then that is a matter which is then dealt with within the commercial relationship between the parties. It is very difficult to impose a public policy decision which can apply to every single contract or every single assignment which might take place.
No, we already have the public policy, which is reflected in the authorities. You're trying to persuade us that that policy has or should be changed in the light of what Parliament has done in relation to contracts which have a different nature and different effect. And you're saying to us that we should no longer follow clear law as set out in the binding authorities you've shown us because of what Parliament has done in relation to a different situation.
It is, that's right. It's in relation to a different situation, but an analogous situation, and certainly one where you can draw from, because as my law says, what one is looking at is the logic behind and the reasons behind why Parliament has done it. And if you weren't to change the common law, turn it on its head, if you weren't to change the common law in line with what Parliament said, then I would say that that is probably causing more mischief. Because if this court accepts that the DBA regulations mean that the conflict of interest which was inherent in solicitors taking claims is no longer something which concerns Parliament, then it'd be odd to turn it on its head and say, well, there were authorities before that which went to that point, and therefore continuing from now on, we are not going to take into account what Parliament has done, but instead we are only going to look at the authorities.
So why has Parliament not repealed Section 59, subsection 2 of the Solicitors Act 1974?
Well, firstly, my interpretation, or my submission on the interpretation, is that it doesn't impact on this area anyway. So it doesn't need to do it. So if one turns to it, it's at tab 2 and page 5 of the authorities manual. What 59.2 says, those sections, or in section 60-63, nothing in those sections validates anything which any such agreement.
But we know that the reason why that was there is because at that point in time, 1974, it was clearly established at common law that you couldn't do it.
But it doesn't validate it. But we say that doesn't, my submission is that nevertheless doesn't prohibit the development of the common law. All it says is that nothing in that specific section validates.
But is it not parliamentary recognition of the common law? And therefore, why should the courts subvert Parliament's recognition of what was well understood to be the pre-existing rule?
Well, you're not subverting it at all. What I'm asking this court to do is recognise that Parliament has expressed a further intention by reason of the 2013 Act. And so the parliamentary intention, of course, can change over time. And by doing so, then one, as they shouldn't then look at the 59.2 Act and say, well, that means that Parliament's intention is no longer something which the common law should take into account. Take the example in the extreme. Suppose the statute had expressly said, we change the common law, or this is our intention. It was there in black and white. Our intention is any contract such as this should be subject to, or no longer subject to the rules of champerty. One couldn't then look at 59.2 and say, well, hang on. No, I know it doesn't work for various isn't, but the principle is you can't look at 59.2 and say, hang on, 59.2 says the common law is now immutable. It's forever. You cannot change it because 59.2 says that nothing in these agreements shall give validity. But all I'm saying is all you read that is saying it doesn't give validity to anything. It doesn't mean that the common law can't change and create another agreement. What it means is that that statute doesn't validate it, but it doesn't prohibit the common law validating it. It just means you can't do it from that
DBA
statute.
doesn't give solicitor isn't equivalent to purchasing an interest in the action, is it? Or it doesn't. Sorry, it doesn't amount to purchasing an interest in the action.
Well, it says, I'm not sure, my lord. It says nothing in this section shall give validity to any purchase by a solicitor of the interest or any part of the interest of his action. So I think it does.
I think it's B that deals with CFAs and DBAs, actually.
Yes, thank you.
Yes, that's the point I'm making. Is I don't think that anything that Parliament did with DBAs or CFAs changes the principle, the concerns about a solicitor purchasing cause of action.
I think I disagree because the 2013 regulations expressly allow it.
They allow purchasing the action.
The reasons behind the 2013 regulations remove any objection that would have existed to the purchase of those.
Well, I think it brings us back to this fundamental question, isn't it? Is whether there's a difference between someone remaining the client and remaining able to give instructions and to control, and a situation where the solicitor just simply takes the client out of the picture, but subject to an agreement to pay him some of the proceeds. In other words, to completely reverse the whole dynamic of the DBA/CFA.
Yeah, then going back to the example about a trustee in bankruptcy, I mean, the trustee in bankruptcy has to still look after the bankrupt and have the bankrupt's interest as well as the creditors. And in that situation, the trustee could sell the claim to a solicitor. And so you'd be in exactly the same situation. You could be in exactly the same situation as if Mr Farrar had not stayed alive, first of all, and not assigned.
Forgive my ignorance. Why can a trustee assign to a solicitor?
A trustee in bankruptcy can sell any cause of action to anyone. There's no prohibition about selling it to a solicitor.
But the problem would be the same, because at that point in time, the trustee in bankruptcy would be the client.
But yes, well, the point I'm making is allowed to
He would
do
simply
it.
step into the bankrupt's shoes.
Yes. Yes.
So the same arguments
It's the same
would apply.
argument. I'm saying because you're permitted to do it, that is why there's nothing wrong with it.
Okay, what goes around in circles at
Yeah,
that
no,
point.
I appreciate that.
Yeah.
But anyway, going back to the specific point about 59.2, I say when one reads 59.2, there is nothing in it which invalidates other agreements. What my lordship's point was, the common law had invalidated other agreements, and this section doesn't validate them. But it's still open for the common law if it wants to, if this court chooses to change. So if the common law validates it, and for different reasons, reasons of public policy which arise because of the 2013 regulations, then it is not affected by this situation, by this statute. This statute purely concerns whether or not it validates, or there's nothing here which actually validates the common law. If the common law changes, the common law changes. This cannot be seen as a bar to the common law changing according to public policy.
Yes, but you're relying upon statute to show that the common law has changed. So one can surely look at the statutes, and not just the ones you want to look at, but all continuing statutory provisions.
Yes, absolutely. I mean, the best, I can't remember the authority now, I'm sure Julie will remember it. Well, there's 2 points. In paragraph 3 of our skeleton, we refer to Hall and Simons, and again, it's the same point, that just because
This is the supplemental skeleton.
this is a supplemental skeleton. and it's a point we make in paragraph 3.2. And 3.1, I don't need to go to it, but the summary is there, Lord Hoffman, simply saying because the court, of course, can make different decisions if it thinks public policy has changed. Doesn't mean the previous decisions were wrong, it simply means that policy has changed. That's all.
Well, you're talking there about a court which wasn't bound by any previous decisions, including its own.
Yes.
So it's much easier for the House of Lords and now Supreme Court to say that it is no longer going to follow policy which is reflected in decisions than it is in a court. I mean, you may say to us, well, we preserve that argument for somewhere, but we are bound by the decisions that refer to us unless we're satisfied that they have been overturned by Parliament.
Or superseded, yes. Absolutely.
Well, what do you mean by superseded?
Policy
What doctrine of precedent enables us to regard binding decisions of the House of Lords as superseded?
No, superseded is the wrong word, but if the decision of the House of Lords is based on a public policy which no longer exists or is no longer deemed to be suitable for modern times, then doctrine of precedent doesn't mean that this court is still bound by the House of Lords. It can depart from it because the basis upon the House of Lords decision is something fundamental which does not exist anymore. So it's not that the decision.
What's the authority for that?
I don't know. Well, I'll come back to you as to authority to see if we have found anything like that.
It's in because they say expressly they're not overturning the previous decision of the House of Lords, but it's also in Whittingham Hospital.
So I'm told two. Firstly, it is in Hall and Simmons. And also in Whittingham Hospital. So I'm going to take you through those, if I may.
Well, Hall and Simmons was in the House of Lords.
Hall and Simmons was in there.
Right, so that doesn't help you.
No, but the point about Hall and Simmons was that policy. Yeah, okay, I take the point about precedent. It doesn't help me.
Whittington might.
Whittington
I don't know.
If I could just have a moment to look at that. Is at page 398 of the supplemental. Under tab. I could just check this. It's looking at paragraph 60. So if I could invite my lady and your lordships to read from 60 and finish at 64.
Forgive me again if you give me the page.
So page
416.
416.
Yeah, but all of that establishes is the point which, at least on one level, is not in dispute, which is that public policy can change over time. Whereas the question that you're being asked is, well, fine, if you're in the Supreme Court, but how does that assist with the doctrine of precedent? And there's not a word in this passage about the doctrine of precedent.
I'll just give her a couple of minutes.
Yeah,
Well, the
and,
reason-
and so far as the precedent point is concerned, the key is at 57, because there was the question that arose out of the previous decision called Briodi. But what he says at 57 is that that was prior to Patel, and therefore, given the supervening decision of the Supreme Court in Patel, one could look again at it.
Yes. I'm just checking one point. And it's whether, excuse me, well, can I look at this over lunch?
Yes, well, let's just look at where we are. You said that there was no difficulty today, and Mr. Cohen must have an opportunity to respond.
I suspect not very much more. If I could have 15 minutes after lunch, subject to just checking this point about public policy and precedent. Because to be fair, I don't know whether there is any authority or not on the point that if public policy changes, does that mean the House of Lords decisions are no longer binding, consulting precedent, or if they are, what this court can do about it, if anything. So I have to look at that.
Well, when you're thinking about that, just bear this in mind. An awful lot of very fundamental concepts in our civil law, including concepts of duty of care, etc., and legality, are based on and are understood to be based on principles of public policy. And if the answer is that it can be argued in any court, well, public policy has shifted since the Supreme Court last pronounced on that area, then that's going to massively undermine the doctrine and usefulness of the doctrine of precedent in this country.
I understand that. I mean, to take the point, if for instance, well, historically gaming contracts were illegal. Parliament then intervened or has intervened to make them legal. Even if there were House of Lords precedent which made it illegal before Parliament intervened, then going forward, it must be open to the court to say, well, Parliament's made it legal, so I'm no longer bound by the House of Lords which says it was illegal. So that it's the same
gaming
point.
contract, the legalisation of certain gaming contracts, such as what was Section 16 of the 1968 Act, etc., is very specific and doesn't very specific legitimisation of certain gaming contracts in very restricted circumstances. And it seems to me it exactly makes the point that the specific parliamentary intervention doesn't undermine the underlying rule of law based on public policy, which was recognised to continue.
It depends on the statute. That's all I can say. It depends on the statute. Because if gaming was something that got picked up, but I take the point that's very specific. But in another area, if the House of Lords decision was based on a public policy, which subsequently one can infer Parliament has now changed.
That's your argument.
Yes.
All right, so 15 minutes at 2 o'clock.
Thank you. Thank you, Lady.
Thank you.